Good evening and welcome to Transition Talks Tuesdays. My name's Tim Markle. I'm the director of the Wisconsin Youth Health Transition Initiative, and we are doing the Spring 2025 Transition Talks Tuesdays in partnership with Mount Horeb Area School District's transition team. Very thankful for the efforts that they are making to improve the experience of transition for their students and their families. Tonight, we have attorney and parent George Zaske, who's presented with us before. We're going to be learning tonight about the stuff he knows about supported decision making and guardianship. Well, at least the stuff he knows that he can cram into about 50 minutes because George has been doing this for a little bit.
Yep.
So I am excited, George, to hear you again. Thank you so much for taking time out and joining us.
Happy to do it. So we do have a PowerPoint presentation. Get that launched.
Is it working on your end, or do you want me to pull it up on my end?
Okay, let me share my screen. Okay, let's see
Okay.
this. Okay. All right, there it is.
Oh, looks like we're going.
All right, yep.
It's
And then I want
appearing.
to, yep, I want to put it in the mhm. What I want to do is, oh, okay, there we go. Why is this not showing up?
I was there a second ago.
Yeah, I know. It says I'm sharing my screen.
Yep, we are now
And
seeing your PowerPoint
okay.
options.
Yeah, that's so what I'm trying to figure out is how do I get my PowerPoint to display? So I was looking at it. Let's take a look down here. Mhm. Okay, so screen sharing is paused. Let's try this again. Share. All right, so there's that. Okay, there's this. Okay, share. And then supported decision making. All right, and I want to get to the slideshow side of things. You seeing it now?
That's looking good. Perfect.
Okay.
All right, moving forward,
Yep.
everyone. Fantastic.
Yeah,
Thanks, George.
sure. Good evening, everyone. Supported decision making has been around for a while. I've been doing presentations on this topic for a number of years, and it sounds like this is with Mount Horeb, so um, hopefully this information is helpful to you and gives you some food for thought, a little bit about who I am. Um, as Tim mentioned, I'm a parent of an adult son with a cognitive disability. I'm also an attorney who's licensed in Minnesota and Wisconsin. I live up in River Falls area, and so I practice in both states. I'm also a board member for a local service provider, so I get some exposure to agency work and providing services for people with disabilities. And I'm also an advocate. I'm a current member of the board for people with developmental disabilities. So I've been involved in this type of work for some time, and it's personally very important to me and also professionally. Uh, as Tim said, I'm here to educate and provoke thoughtful family discussion, deciding whether to go with a guardianship or whether to go with a supported decision-making option or other options to support your loved one with a disability, is the more information I think you have, the the better the discussion is and the better the option is for your loved one. And so it's a disclaimer for a lawyer. I'm not giving you legal advice that should be relied upon because I don't know your individual facts. So now I got the professional stuff out of the way. Um, I always do a PSA, and my PSA is for an ABLE account. A lot of people, it's been around for now 10 years. And surprisingly, there are a lot of people who do not know about ABLE accounts. It allows you to put money aside for your loved one for um, qualified disability expenses. You can put in up to $19,000 a year, and saving that money up does not impact your benefits calculation. So I encourage you to go to that website, www.able, NRC, which stands for National Resource Center.org, and educate yourself because it can be a very powerful tool for improving the quality of life for your loved ones. So I they've been around for a while, and I know that our numbers are not where we'd like them to be in the disability world. So I usually do a PSA at the beginning of whatever presentation I'm doing. So what is supported decision making? If you look at the definition, and this is around 2012, which now is about 15 years ago. To give you an idea how long this has been a concept and utilized, it generally occurs when people with disabilities use friends and family members to help them understand the choices that they make, that they have and face, and that they get to make their own decision without using a substitute decision maker such as a guardian. And that's sort of a key point between supported decision making and guardianship. When you're in a supported decision making role, you are a supporter. You help the person gather information, process the pros and cons, but they are the ones who make the decision. In the guardianship, it's important that you consult with the person under guardianship, but the person making the decision is actually the guardian. So they replace the person with a disability, and they are the ones who make the decision. And I'll go a little bit about the current state that we're in. As I said, I've given this presentation for a number of years now, and I like to point out that the world is changing. And a number of years ago, there was the Olmstead decision, which required people receive their services in their homes, and that's where the home and community-based waiver is about. The CMA, the Center for Medicaid and Medicare, it should be CMS, final rule also talks about people being served in their homes and in the community and not being institutionalized. There's also person-centered planning. There's co-decision making. Maybe some of you have heard of circles of support for folks with disabilities. There are ABLE accounts. As I said, in the early 2010, ABLE accounts didn't exist. So with ABLE accounts, there's more opportunity to improve someone's quality of life in terms of technology, housing, education. There are also representation agreements, of which supported decision making is one. A number of years ago, Project Search was expanded here in the state of Wisconsin. My son went through it. It helped him improve and enhance his job skills, and currently he is employed in the community at market-based wages. There's also a program called Think College, where people with disabilities are involved in college curriculum. There's support available for them. I know there's one down in Madison called Edgewood, and there's one over in the Twin Cities. Bethel College has a program for people with disabilities and to get the support. That's not something that existed so a number of years ago. It's very expensive, and which is why an ABLE account might be a way for people to save up money to be able to pay for tuition. The other thing that's been changing is attorneys are being educated and trained in alternatives to guardianship, because the concept of guardianship has been around since Roman times. So it's thousands of years old, where um, people would have their affairs managed by a guardian. Oftentimes it was for a minor, but it also included people with cognitive disability. The Attorneys Association, the American Bar Association, recognizes supported decision making as an option. It's still a process of educating not only attorneys, family members, but also the courts. And one of the reasons why supported decision making is being considered and is really critically important is, with neuroscience, we've determined that a person's brain does not fully develop until around age 25. And this happens whether you have a disability or not. And I'm often, when I give these presentations, reminded of some of the decisions I made in my, 20, 21, that my parents did not think were very good decisions, but I was a legal adult. I was able to make them, but the brain is not fully developed until around age 25. And the changes in the brain are in the executive functions, the frontal lobe, as well as increased connectivity, so that if you have opportunities to make decisions, to learn from those decisions, and it gets reinforced, that connectivity helps your brain to develop. And the areas that are impacted are things like attention, complex planning, decision making, impulse control, logical thinking, organized thinking, personality development, and risk management. And the thing about that critical window between 18 and 25, and that's 6 to 7 years, if you're put under a guardianship, oftentimes people weren't given an opportunity to practice making decisions, and people were sheltered and protected, and decisions were made for them. And without having the opportunity to practice, if you will, those areas of the brain never really developed, so that people would get stuck. And the thing that promotes this healthy brain development are cognitive challenges. Education, I mentioned Think College. There's education beyond high school. There is a program over in New Richmond for the Northwoods Technical College that also allows students with a disability to be able to take training and can further their education in the technical school realm. It also is important to have uh, busy and complex social life, which gives you the ability to work with others, to understand how to interact with other people. And those opportunities, the more you have them in that time frame between 17 to 25, the better it is for an individual to have that healthy brain development. And that gets stunted when you're put under a guardianship at 17 and a half. I go through a guardianship petition. This is what the court will use to appoint a guardian for a ward. And this form is available online through the court's website. And one of the things that we've seen is it's pretty easy for people to petition the court, fill out the paperwork, and people will oftentimes do it by themselves. We refer to that as pro se. They don't have an attorney. And that may not be the best option. If you talk with an attorney, you can have an opportunity to weigh the pros and cons, but if you're just not going to use an attorney and you just start filling out the form, it's 7 pages. It's used for a temporary guardianship, a permanent guardianship, and it's due to incompetency. And you can see this form is a checkbox, so you can fill in the individual's name. You can say why you're interested, where the person lives, and then all the people that are what we call interested parties. Could be siblings, aunts and uncles, to let the wider world know that somebody's likely to be placed under guardianship. And through this paperwork, as you can see, it's not very involved. You can say you want guardianship of the person, guardianship of the estate, which is the financials. You identify the amount of property the individual has. And then you can go down near the bottom of page 2 here and you can ask for permanent guardianship. And basically, when you go through this form, it's just a series of checkboxes. And you remove rights. For example, partway down the page, you can remove under 15A, you can remove a person's right to vote. And there is a different level of competency for determining voting decisions of who you want to select to vote, as opposed to, say, for example, a complex financial contract or a loan agreement. So there's a lot of difference in levels of competency, but if that gets checked and a guardianship is put on, a person can lose their right to vote. And I would argue that decision making, that competency level, is not the same as for an informed medical decision, for example. So you can just go down and check these boxes, and each time you check a box, you remove that person's civil rights if the court order is granted. Now, people can do what we call a limited guardianship, and they can check a box that, for example, if you look under C, AC, it says individual remains limited capacity and power to. So you can limit how much power is given to the guardian, but oftentimes people will just check all the boxes and get a full guardianship on the individual. And oftentimes it is the parent, and the court gives a lot of deference to parents because they've raised that child, they've lived with that child, and the parents generally want to default to keeping their child safe because they know they're vulnerable. So oftentimes they just check all these boxes and remove all an individual's civil rights and sign the form, pay the filing fee, and get a hearing. I mean, it's more involved than that. But I gave a presentation one time and on guardianship, specifically not supported decision making. And I had somebody in the audience time me, and I filled out the form in front of everybody. And I was able to do it in about, and I'm experienced as an attorney, but I was able to do it in about 10 minutes. So I was able to fill out a form, a petition to the court to remove somebody's civil rights, who they can associate with, what happened, where they live, their medical decisions, what happens with their resources. I was able to fill out that form in about 15 minutes. And when you can think about the magnitude of what's a guardianship takes in terms of rights and transfers the power to make those decisions to somebody else, and you really do it in about 10 minutes. It doesn't strike me as where you're really weighing the importance and significance the um, gravitas of applying for getting a guardianship. Now, there's not a lot of studies and information around guardianships. When I did some research, a study in 1994 that found a majority of guardianship hearings last about 15 minutes. And I have personally experienced that in my profession, where it's just pretty much a conveyor belt assembly. The paperwork's filed, the physician's report is entered in evidence. If there's nobody to dispute it, or the person under proposed ward it doesn't fight the guardianship, it can happen pretty darn quick. And that's the sort of a powerful juxtaposition that I look at. And it's like you remove somebody's civil rights and it can be done in about 15 minutes. And once a guardianship is put on, they're very hard to undo. They're very hard to undo. And that can last for that person's life. So if it gets put on at 18 years old and that person is going to live into their 60s, you're looking at, 40 or 50 years of guardianship where somebody else is making that person's decisions. The question is guardianship the best option? It says that, there's studies that show that only about 25 to 50% of families of adults with disabilities make concrete plans for the future for the adult with developmental disabilities. People find that someone with a cognitive disability lives with their parent well into middle age. They're the primary caregiver. They have been that primary caregiver and support for the life of that individual. And eventually there will be a transition. And usually the transition shows up with either the death or infirmment of the parent. And that's the other nice thing about considering a supported decision-making option is it gives the child, the adult child, your adult child, an opportunity to make decisions, to learn from those decisions. And you can continue to provide lessons and opportunities so that when there is a transition to independence, you can do it in a measured and supported way as opposed to a transition in crisis. And for many years, guardianship was described as a standard practice of taking care of the planning for the future of a person with an intellectual disability. And the guardianship implicates a person's constitutional right. It's been said that a person in the correction system in prison has more rights than someone under guardianship. It is the court-ordered loss of personal freedoms. Here's the statute that the court uses. And I had a friend of mine who he's retired now, an attorney who I used to co-present with by the name of Mitch. And he always made a point to read this statute and paragraph 3, subsection B, because oftentimes people who are made guardians seem to think that they can just continue on with their parenting role. It is a very distinct role from being the parent. You will always be the parent of your child. That doesn't change. But being a guardian for your child who is now considered a ward is a very different relationship. And you have to make an effort if you're a guardian to identify and honor an individual's preferences. And you have to take into account what their wishes are and what they want to be able to do. And there are instances, as I said, I'm board chair for an agency that provides day services. And we require that the guardian place a copy of the court order in the file for the person that we are providing services for, because we want to make sure that if we're told something from the guardian about what to do around services, that that is expressly identified and authorized within the guardianship order. Often it can be sort of standard where you're a parent, your child's 19, you're getting him some services, and it's just sort of the default. Mom and dad have been making those decisions. Mom and dad will continue to make those decisions, and maybe the guardianship is limited and they can't be making decisions in a particular area. So that's something that we very much require with our organization, because we want to know what powers the guardian has. Because I've had a number of anecdotal instances where people have said that a client in their care, having gotten to know them for a while, they feel like they could do a lot more if only their parent slash guardian would allow it. So are there alternatives? Yes. One of the things that you can do is petition for the appointment of a conservator. That's a person who would be in charge of the money. There's not a lot a person can do if you control the money, in terms of, can they pay for an apartment? Can they pay for a car? So you could allow them to have decision making over their person, and you could have some influence around what money is available for what it is they want to be able to do. And then that way they are not under a guardianship of the person. Now, when you turn 18, you are presumed competent. That's just a matter of law. That you turn 18, you're presumed competent, that you can sign documents, and until you're determined by a court after a evidentiary hearing that you are incompetent, you can sign documents. And one of the documents that can be utilized is a durable power of attorney for finance and property. So you could have your loved one fill one of these things out, and that would allow you to help them make decisions, be co-signers on a bank account, those sorts of things, help them, get a credit card, manage paying that off. So a durable power of attorney for finances and property is an option. People use these, for example, with their elderly parents. So they've been around a long time. They're available for download um, online at the state. So you don't really need to get a lawyer involved to get one of these. They can be revoked by the person who signed it. So it's not locked in. People can revoke them and appoint somebody else to be their what's called an attorney in fact. There's also a power of attorney for healthcare. That usually comes into play when the person who signs this document is incapacitated medically. For example, they're either in a coma, maybe the drugs they're taking, they're in and out of lucidity, they're unconscious, and so they appoint somebody to make healthcare decisions for them. This is not to be used to make healthcare decisions for somebody who's not medically impacted in sort of the day-to-day things, like, oh, we're going to decide this person will or will not get a vaccination, for example. One of the things I was able to do because of my background is I was able to create custom releases, but you can also do releases. Oftentimes banks, financial institutions, healthcare institutions, doctors, clinics, they have releases that you'll need to sign so that they can share information with you, so your loved one can fill out a release. And that can help you support them. I mentioned not checking all the boxes so that you have what's called a limited guardianship as opposed to a full guardianship. So that's another option, another alternative. Um, but that sort of lays out the environment that we have now currently and what has come along in the last better than decade um, is the supported decision making. And it is not a form. It's a mindset, it's an approach. There's a form that's used, but it is not simply a form. Supported decision making is a series of relationships, practices, agreements. They can be uh, more formal or less formal, and they're designed to assist the individual with a disability to make and communicate to others decisions about their life. So you can have a supported decision-making agreement with somebody for your finances, and then somebody else can be your supporter for making decisions around your health care. Or it could be limited. You are looking to make a purchase and you want help with that, and that person can help you make that purchase, and then that's the limited time for that supported decision-making document. And you go through the process. For example, maybe you want to buy a car. You look at different models, you look at different financing. That person helps you buy the car. And then after that purchase is made, you get insurance, that they're done. The supported decision-making agreement is time limited based on an action that you needed help with. This slide was from a attorney friend of mine, Kate Schilling, that was at a CLE I went to a number of years ago. Like to give proper attribution. Supported decision making is still developing. There are institutions that are working with the advocacy community, because in this area, this could impact things like adult protection. It could impact service providers. It can impact healthcare providers, or financial institutions, because they're very geared and keyed into, for years and years and years, the idea of having guardianship. So something different than that can be off-putting, and they need to be educated as well. So we're trying to help institutions understand what a supported decision making is. We're also wanting to educate, and in this instance is really great, is the schools, because that was seen when you looked at the data as sort of what we call the on-ramp to guardianship. When people got near the end of their school time, under IDEA and moving into that transition period, people were told, okay, you better get long-term care benefits, you better apply for Social Security, you should get guardianship, because if you don't have guardianship, you could be excluded from an IEP meeting. And that's true. But if you have a good relationship with your child, they can certainly agree to have mom and dad involved in the IEP. Are there risks associated with it? Yes. But when you weigh the pros and cons, that is something to consider. So the values of supported decision making, again, a slide from Ms. Schilling. The idea of autonomy, self-direction. It's the least restrictive option. That is one fundamental concept involved in supported decision making as well as in guardianship. What is the least restrictive conditions that we can put around an individual with a disability for them to move about in the world? It's not a way of, we just want to lock somebody down. What is the least restrictive? And we're finding now that because of the supported decision making law that was passed a number of years ago in Wisconsin, that is actually a question that some uh, judges are now asking in guardianship hearings. They're asking, has supported decision making been considered or tried? And if so, why didn't it work and why are we here for a guardianship? They don't just want people coming in and just rubber stamping a guardianship. And it also helps build trust, and provides it provides for the respect of the individual themselves. When somebody's put under guardianship, even with limited intellectual capacity, they know they've lost something. They know somebody else is going to make their decisions for them. And it can be very depressing, and it can cause strife and challenges in family relationships between, if you have a sibling that's appointed a guardian, that can change that sibling dynamic. So that's something to consider as well. The other concepts to consider is presumed competence. Don't presume incompetence or they can't do it. Presume that they are competent. There's the idea of dignity of risk, and that we all are able to make decisions and make mistakes. And some of the decisions we make, the mistakes, can be financial. You certainly don't want to have somebody making decisions or put them in a place where their first big decision, they hit the pavement and really hurt themselves emotionally, financially, or even physically. But we all want to have the right to take a risk and learn from the mistake if it doesn't work out. And the other thing I mentioned earlier is the difference between a substitute decision maker as a which is a guardianship versus a supported decision maker. So the new state laws are being enacted. When I first started giving this presentation, there were 5 states that had supported decision-making laws on the books. And one of my irritations was the state of Texas had a supported decision-making law before the state of Wisconsin. But as you can see, Alaska, Colorado, Delaware, all the way through, and when these have come in, and this also goes back to my point about the world is changing. Colorado, only 4 years ago implemented this. The state of Minnesota does not have supported decision making. I know they're looking at it. I've given presentations over there about what we've done here in Wisconsin. But one of the things that Minnesota did a couple of years ago, which I really wish Wisconsin would do, is what's called a time-limited guardianship. And for anyone under 30, if they're placed under guardianship, it's for 72 months. And then you go back to court and look at whether or not the guardianship is still necessary, the scope of the guardianship is still necessary. And so this provides an opportunity for people to get back into court and take another look at this case file, as opposed to sending them off and you don't hear about that person from the court's perspective forever. So while they don't have supported decision making, they do have a time limited guardianship, and I think that we've talked about doing something like that here in Wisconsin. Part of the change that's happening is there's a group called Wings, and that is a collection, a group of people. It has judges, it has attorneys, it has professional guardians, it has guardian ad litems, and they get together on a regular basis to talk about improvements to the guardianship process, improvements to supporting people who have cognitive disabilities. As I said, there's attorney training that's going on. When I actually presented to the Minnesota version of Wings a number of years ago to talk about what we did in Wisconsin. And supported decision making is a statute. It's Chapter 52. if you want to take a look at it. There's also self-determination training where we're educating people with a disability about how to work with the supported decision-making document and find supporters and have more input and say in what their life looks like. Now, a number of years ago, there was a real life case in Virginia where a young woman, contested a guardianship that her mother wanted to place on her. And everyone who goes under guardianship has a right to contest it. I got a call about a month ago where somebody would serve papers and they thought they were just going to be put under guardianship. And I um, informed them, advised them that they do have a right under the statute to ask if they can't afford their own attorney to ask that one be appointed to contest the guardianship. And this one received national attention. Um, and it turned out, the long story short, is she was put under a guardianship by her mother, but the judge, based on the evidence and what he heard, made it for a year and instructed the guardian. And it wasn't the mother who was the guardian, it was some friends of the daughter who were made guardian. And they were to come back in a year to see if with the express purpose of removing the guardianship, because that year that she was under guardianship, they were supposed to make a really strong effort to increase her decision-making skills, to increase her independence so that she was no longer in need of a guardianship. And in fact, after a year, they came back to court and the guardianship was removed. So here are a number of resources. I do believe the PowerPoint will be made available to people. Tim, I think that's been the standard practice.
That is correct. We'll send out the PowerPoint as well as the resource sheet.
Yep. So as I said, I'm on the board for people with developmental disabilities. They have a packet that provides the forms. Another area for learning about guardianship and supported decision making is the Greater Wisconsin Agency on Aging Resources, sometimes called GWAR. You can see that in their website link. It's a little bit of a mystery how it got placed there, because it's not just aging. It's the guardianship for people, transitioning from 17 to 18 to adulthood. There's information there. There's also the National Resource Center for Supported Decision Making. The Wisconsin Department of Health Services has information and publications on supported decision making, as well as other forms that may be helpful in terms of doing an alternative to guardianship. The Minnesota Department of Health Services, they have some YouTube videos talking about guardianship and the role, the responsibility that a guardian has. A couple of years ago, I was part of a group that put forth a change to the statute for guardianship that now requires, before you can be a guardian, you have to go through a training program. And that training program was developed with the University of Wisconsin Green Bay. It's online, and you need to go through that training. It exposes you to a number of concepts that we've talked about, as well as what your duties are as a guardian. And there's some online testing associated with it. And after you complete the training, you're given a certificate, and that has to be included in the filing before you could be appointed as a guardian. Any questions? I'm going to stop sharing my screen. And then I see there was a number of chats.
Yeah, I of course have been putting all sorts of links that you talk about, George, as best I
Hmm.
can,
Yep.
into the chats there. Let me see if I can go you up a little bit. Here we go. All right. There we go. Now I'm back with you. So we have a question in the chat. Is the guardianship form the same for the entire state or is different per county? Because I know people go to the county level, the circuit courts for the form, I believe. So is it the
Right.
same
And
form?
it's the same form for the whole state. Now, what you'll find is sometimes uh, different counties will have their own county-based rules. Um, so sometimes it can be a little bit of a surprise. You have a process in place as an attorney, and then you go to a, a smaller outstate county, and they have their way of doing things. But they all use the same court-approved form that I showed you, um, and that's something that um, every court uses. The thing with guardianships in some of your bigger um, communities like Milwaukee, Madison, they have, dedicated courts, dedicated judges who know a guardianship law really, really well. It's under the probate division of the courts. There's a family court, there's a criminal court, there's civil court, and there's probate court. So it's broken out. But you go to some of your smaller, northern counties, like Rusk or Barron County, judges up there, and there may only be three judges for the whole
Well,
county. They have to do it all. And they kind of get assigned, and they'll stay with criminal for a while, and they'll rotate, but they don't necessarily get a lot of guardianship cases in the course of a year. So how often they visit the statutes, um, can be very different than applying for a guardianship in Milwaukee, for example.
then a follow-up question, does the guardianship process have to take place in the county of residence?
Yes, because that's where the court would have jurisdiction over the person in that um, in that county where their residence is. And that's like, for example, where the guardianship order would take effect. If somebody were in a group home in, now that's not to say you can't move somebody once a guardianship is established through the state, but the initiation is where the resident of the proposed ward.
Okay, another question. Would having support decision-making agreement versus guardianship, do you know if there's been any impact on a disability application?
I mean, this has kind of been around, and it's sort of part of that myth that's out there. If you have guardianship, the idea was, well, if you're under guardianship, it's a slam dunk for getting
Disability.
benefits.
Yeah.
You gotta have a disability. I wouldn't be under guardianship. That really isn't accurate. You can be determined to have a disability, a cognitive disability, and apply for benefits and be determined to be disabled. They're not they're not linked, but I can see, sort of, uh, you know, m- uh, community could see where, oh, if I'm under guardianship, obviously I have a disability. The court determined that, so I don't have to worry so much about the disability determination process. You still have to go to the ADRC, and they'll want to know if you are under guardianship, but the screening or the application for getting benefits is based on activities of daily living, ADLs. And, you could be disabled and you have trouble with a number of activities of daily living. And so you're determined to be disabled. You don't have to be under guardianship to get that determination.
Another question, can you request a time-limited temporary guardianship in Wisconsin, or is that just not available?
Nope, it's not a thing, which is why we're trying to get the law changed.
I think
And
that's
I mean,
brilliant.
it would make sense. And when you look at the petition, it says temporary guardianship, but that form is used for all types of guardianship. And one of the types that it's used for would be it's a different statute that's used, but it's for protective placement. Oftentimes, it can be used for a mental health crisis or somebody who has substance abuse and they need to be put in treatment. So you can go for a temporary guardianship to support them while they go through treatment, either substance abuse or mental health treatment. Um, so that's on there, and sometimes will confuse people thinking, "Oh, I can make it temporary." That's not what it's for. It's a form that's used for a lot of things. So,
Is there a vetting process for the individual who's going to be the guardian? Does anybody check them out?
well, that you have to do a back. Anybody other than a parent has to go through a background check. It used to be even parents had to go through background check, but they changed that. They felt that it was a little redundant. Um, but as I mentioned, we now have a training requirement so that people can understand what their role is. And and also, if you're trying to identify a successor guardian, that's a good place to send them so that they can understand if they take over for mom and dad, whether it's a cousin or a sibling, for example. But usually, if you move from a family guardian to a corporate guardian, they their staff has been under scrutiny so that they've gone through a background check as well as they have regular training for that. But the thing with corporate guardians, I mean, their case files are pretty huge. They're like, 40 to 50. And if you think about how many that number and just and it's that high, if you say take it down to, just for discussion purposes here, if they only had 30, they would only be able to stop in really and see their ward how many times in the course of a month if they had 30 guardianships in their case file. And if they're scattered around the state, maybe they could see two a day. And you've got what, 20 work days. Um, and so would they really know that person to be able to provide them with the support they need to live the as good a quality of life as they can. Um, but yeah, people are uh, go through a background check.
Any final questions before we close out for tonight? Give people a little chance
Hmm.
to type, George, as I say
Yep,
thank you
sure.
very much. I appreciate it. Some thanks coming through in the chat as well.
Okay,
So thanks again. I will get the PowerPoint out as well as the resource sheet as soon as I can.
sure.
And George, thank you again
You're
for
welcome.
just helping. I know it's not simple, but
Yep.
at least helping it make it a little bit more understandable
Yeah.
for
Yeah, and this guardianship, supported decision making, it's a process. You get educated, and then you come across hypothetical questions of what about what do we do when it comes to medical decisions and medication and when they're going to move out. And I believe this is critically important, and I'm happy to do it. I think the more education we have out there, the more people asking questions, the better it will be for our community in the larger sense of the word. So happy
totally
to do
agree.
it. Hopefully it was of use to folks. So,
Oh, I believe so. From the
all right.
questions, people are interactive and then the questions. So thank you so
All right.
much.
Okay.